Hey everybody, Stephanie here with the Machine Gun Nest with our newest legal update. And I have some cool stats to share, and then we're going to move into an update with the New York State Rifle and Pistol Association versus BRUEN. So, some new poll numbers have just been released by Gallup indicating that support for more gun control is at an absolute all-time low. So despite what the mainstream media is saying, that the poll numbers are actually indicating that Americans are not in favor of more gun control. I'm going to read you some numbers. Overall, the support for gun control, more strict gun control, has actually dropped 5 points and is now at overall 52%. Amongst Republicans, it has dropped 14% to 22%. So only 22% of registered Republicans are in favor of stricter gun control laws. Amongst independents, it has dropped 15 points, and actually among Democrats, it has risen to 91%. So there's definitely some polarization happening, but overall those numbers are coming down. But listen to this. We learned that the support for handgun bans overall has dropped significantly amongst all parties and is at a collective all-time low. So it's been below 30% since 2008, but right now, this is again amongst all parties, it's at 19%. This is an absolute all-time low. So the American people clearly are not in favor of banning handguns. What's fascinating about all of this, though, is we can expect that Republicans are not in favor of more strict gun control and that Democrats typically are. But for 15% of independents to now not be in favor of this, for that 15% drop to happen, is really, really huge. And that indicates the direction our country is taking, is moving, and potentially will be going, because those are the people that are actually going to swing and change what is happening within our legislature. So that's fascinating. And so now that takes us into New York State Rifle and Pistol Association. I know we've talked about this ad nauseum almost, but we just can't overemphasize the importance of this case and the precedent that it could set. So again, if you're just joining us now, this case deals with whether or not your Second Amendment right exists outside of your home and into the realm of personal protection. So I just kind of want to give an overview of what has happened. We've had some opening arguments in the beginning of the month of November here, and we had some great points made by both sides, and we just want to dissect them a little so that if you decide to watch what is happening next, you'll be informed. So the justices all came in, and what was fascinating to us right off the bat, and we're going to link our live comments below so that you can check it out if you'd like to, is that most of these Supreme Court justices are not fully informed or are aware of the nuances of gun law on a national, federal level, or even in the state of New York where they are. So with that being said, the past year or so, we see, oh, so-and-so filed an amicus brief, so-and-so filed an amicus brief. Those briefs are really important because that is what the justices are reading to gain their information about this case to help them make a more informed decision. Here are some notable briefs that have been filed in support of our gun rights. We have the NRA Civil Rights Defense Fund. We have Ted Cruz and 24 other senators. So that's a quarter of our nation's Senate that have gotten together to file a brief. The Cato Institute, Gun Owners of America, and the Heller Foundation. The state of Arizona, NSSF, we love NSSF, National African American Gun Association, Firearms Policy Coalition. They're doing a phenomenal job of helping our gun rights here. But what's interesting, and probably one of the most impactful briefs, not necessarily from just an informational perspective, but based on who is filing, were the New York Public Defenders. So New York Public Defenders, those are the people who are defending those who cannot defend themselves. They are defending those who don't have the funds to defend themselves. So for them to file an amicus brief in support of our gun rights really indicates what's going on from who actually has a pulse on our society. Because right now, what the case is talking about is, do people who do not have a good and substantial reason have a Second Amendment right? And so we're going to get into a little bit about what was said and what that means. So we had petitioner Paul Clement, and then we had Miss Barbara Underwood, the Solicitor General of New York, and Brian Fletcher, who is the Principal Deputy Solicitor General of the DOJ. And they put forth some really wonky arguments that I don't think hold water. I'm not a lawyer, I'm not an attorney, but trust me, you don't need to be one to see the holes in their arguments. So here are some of their premises. One, Miss Barbara Underwood said that population density equals less of a need for a gun, and therefore there's less crime.
If you go right to history and tradition, the history was to regulate most strenuously in densely populated places. That's what fairs and markets are. So we have history, but we also have a rationale for that history, which is that where there is dense population, there is also the deterrent of lots of people, and there is the availability of law enforcement. In England, the idea was that it was the king's peace, and it was in fact an insult to the king for people to take things into their own hands.
Well, but that's not always true. It depends, obviously, in the jurisdiction and all that, but simply because a place is, well, it's paradoxical that you say a place is a high crime area, but don't worry about it because there are a lot of police around. Purpose of the Second Amendment is to allow people to protect themselves. That's implicated when you're in a high crime area. It's not implicated when you're out in the woods.
Well, I think it is implicated when you're out in the woods. It's just a different set of problems. I mean, you're deserted there, and you can't, and law enforcement is not available to come to your aid if something does happen. But
well, how many muggings take place in the forest?
How
many do you think?
I don't know, but I will tell you that our licensing officer told us that rapes and robberies happen on the deserted bike paths, and that he has some concern about that. So, I mean, I take your point that there is a different risk in the city, but there is also a different public safety consideration, and that is why the licensing officer is meant to take into account not just the risk, but also the population and the availability of law enforcement and all these considerations.
I mean, that is just an absurd proposition and demonstrably false. According to Ms. Barbara Underwood, if you are in the woods versus in, a densely populated metropolitan area, you shouldn't need to be able to carry a gun. And it's crazy because you're not going to get mugged in the woods. You're not going to be brutally attacked in the woods. I mean, sure, that can happen, and you absolutely have the right to defend yourself in the woods, but those things are just really, really unlikely. It's in a densely populated area that you want to be able to protect yourself. So that was just utterly torn apart. Ms. Barbara Underwood also was advocating for a subjective application.
I think the extra problem in Manhattan is that your hypothetical quite appropriately entailed the subways, entailed public transit, and there are lots of people on the subways even at midnight, as I can say from personal experience, and the particular specter of a lot of armed people in an enclosed space.
There are a lot of armed people on the streets of New York and in the subways late at night right now, aren't there?
I don't know that there are a lot of armed people.
No?
There are people with illegal guns, if
that's what I'm talking about.
Yeah.
How many illegal guns were seized by the New York Police Department last year? Do you have any idea?
I don't have that number, but I'm sure it's a substantial number.
But the people, all these people with illegal guns, they're on the subway, they're walking around the streets, but the ordinary, hardworking, law-abiding people I mentioned, no, they can't be armed.
So what is behind all of this? The good and substantial reason means that somebody is going to arbitrarily decide if your life is worth protecting.
The other question is, why isn't it good enough to say I live in a violent area and I want to be able to defend myself?
Well, what happens in these license hearings is that a question is asked, what exactly do you mean? Because
the statistics.
It depends on how large an area you describe. You could say I live in a violent area, and that could be all of New York City, or it could be your particular neighborhood. And the closer it gets to your particular neighborhood, the better your claim is, or your block. Now, I know that one of the petitioners made an assertion about robberies on his block. I also know that there was a hearing about that, and he evidently did not convince the licensing officer that they were sufficiently recent or relevant or couldn't be dealt with adequately by his own premises license, which he would be entitled to have without any justification or proper cause at all. So what I know happens is that those claims are examined by a licensing officer. Now, this gets to to questions about discretion and whether that's effectively handled, but
well, that's the real concern, isn't it, with any constitutional right? If it's the discretion of an individual officer, that seems inconsistent with an objective constitutional right.
But what's fascinating is that the Supreme Court justices said, okay, Miss Underwood, but if I'm a runner and I'm running through Central Park, in New York City, should I be allowed to carry a gun? And she said, well, in that case, yes. And it's just fascinating because she was undoing her own logic throughout her opening statements. And it revealed that these people just don't have a leg to stand on.
What if you're a runner? You say, I run a lot. And as you correctly pointed out earlier, there are a lot of serious violent crimes on running paths. It's a real problem. Is that good enough?
Probably. I mean, that's the counterpart to Nash's claim. But
probably,
if that's the question, that is not the way this case was tried. That's not the way this claim was framed. And if the question is, does the system actually operate in the way that we're describing, then this case should be remanded for a hearing to determine whether it does.
And what's the problem with the shall issue regimes from your perspective that exist in many other states, including very populous states, Florida, Illinois?
The problem with the shall issue regimes is that they multiply the number of firearms that are being carried in very densely populated places, and there is a much higher risk, without assuming any ill intent on the part of the carriers of weapons. They greatly proliferate the likelihood that mistakes will be made, fights will break out.
But has that happened in those states? I mean, can you make a comparative judgment? Because it seems like before you impose more restrictions on individual citizens and infringe their constitutional rights based on this theory, you should have to show, well, in those other states that have shall issue regimes, actually there is a lot more accidents, crime, and I don't see any real evidence of that.
She did say that, okay, I concede that subjective application might not be the best, but we should relegate this to maybe hyper-local authorities. So let's say you live in upstate New York and you want your local sheriff to then be the arbiter of if your life is worth protecting or not. But the problem is she's still not fixing the problem of subjective application. It is just wholly unfair to have somebody sit across a desk from you or talk on the phone and say, no, you know what, your life isn't worth protecting. I'm going to give you a no. You're a wealthy business owner. You fulfill our requirements, so I'm going to grant you permission to defend yourself. And what's fascinating behind all of this is that it's typically minorities, people of color who are affected by this awful legislation. The justices rightly brought up, okay, what if somebody's cleaning offices, right? They're cleaning offices in a challenging part of town, a dangerous part of town. They get off work at midnight and they have to walk to a bus stop or walk to wherever their transportation is through a rough neighborhood. That person, as the law stands right now, would never stand a chance, which is ridiculous because that person is more likely to need that permit.
Could I explore what that means for ordinary law-abiding citizens who feel they need to carry a firearm for self-defense? So I want you to think about people like this, people who work late at night in Manhattan. It might be somebody who cleans offices, it might be a doorman at an apartment, might be a nurse or an orderly, might be somebody who washes dishes. None of these people has a criminal record. They're all law-abiding citizens. They get off work around midnight, maybe even after midnight. They have to commute home by subway, maybe by bus. When they arrive at the subway station or the bus stop, they have to walk some distance through a high-crime area, and they apply for a license and they say, look, nobody has said, I am going to mug you next Thursday. However, there have been a lot of muggings in this area, and I am scared to death. They do not get licenses. Is that right?
That is, in general, right, yes. If there's nothing particular to them. That's right.
How is that consistent with the core right to self-defense, which is protected by the Second Amendment?
Because the core right to self-defense doesn't, as this court said, doesn't allow for all to be armed for all possible confrontations in all places.
No, it doesn't, but it doesn't mean that there is the right to self-defense for celebrities and state judges and retired police officers, but pretty much not for the kind of ordinary people who have a real felt need to carry a gun to protect themselves.
I mean, it's just terrible. So after she was finished with her arguments, Brian Fletcher, who is the Principal Deputy Solicitor General of the DOJ, came on the scene, and he put forth some really crazy premises also. One was that the 8 states that do have a May issue scheme set a precedent of what equals protection.
Tennessee enacted one of those laws in 1821. Texas followed in 1871. New Mexico and Arkansas likewise enacted such laws in the years immediately after the ratification of the 14th Amendment. And over the decades that followed, more than a dozen other states enacted other laws that were at least as restrictive as New York's. Like my friends from New York, I count about 20 laws in total that fit that description. Those laws remain in force in 7 states today, and more than 80 million Americans live under their protection. They are, in short, both traditional and common regulations.
Which is just absurd because we have so many other states that show that a shall issue scheme isn't leading to more violence. It actually statistically is less violent in those areas. So that just fell on its face immediately. And he thinks that length of time under the law equals validation and national tradition, but we all know that something, just because it's been a law for a certain period of time, doesn't make it right, and it doesn't mean that we should continue with such a thing. I mean, look at slavery. That was valid in the United States for a long time, and the length of time that was valid doesn't mean that that was right and that we should continue with such a thing. He also, interesting, agreed with the Heller decision and agreed that a precedent was set and should be applied in this case. But listen to this. He also put forth historical tradition, but many of the historical traditions that he put forth were based on what is the equivalent of redlining.
There's a debate about the impetus for the enactment of the Sullivan Law, is there not? There are those who argue, and they cite support for this interpretation that a major reason for the enactment of the Sullivan Law was the belief that certain disfavored groups, members of labor unions, blacks and Italians, were carrying guns, and they were dangerous people, and they wanted them disarmed.
There have been those arguments made, and there's certainly evidence that those sentiments existed in New York at the time. I have not seen things that persuade me that those were the impetus for the Sullivan Law, and to the extent that that was a question, I think the fact that similar laws have been enacted and maintained, not just in New York and not just at that moment in time, but in a number of different states throughout the country, throughout large swaths of our nation's history, is a good reason to believe that this is not just prejudice, that this is a legitimate regulation. One is that I think everyone agrees that the right codified in the Second Amendment is a right that is subject to some reasonable regulations, and in deciding what regulations are reasonable, we think the fact that they've been prevalent throughout our history is a good sign that they are. We think that's especially so because of a point that this court made in McDonald, which is that throughout the nation's history, this is a right that's been recognized and codified in state constitutions as well. It's not something that people were not aware of, and so the fact that this type of regulation coexisted for so long with that understanding, we think is a particularly strong indication of its consistency.
Well, Heller, and I will stop after this, Heller cited decisions going into the 19th century as confirmation of what it had already concluded based on text and history at or before the time of the adoption of the Second Amendment. It said this is what it was understood to mean at the time, and it's further evidence that this is what this right was understood to mean because it kept being reaffirmed by decisions that came after. But I find it hard to understand how later decisions and statutes, particularly when you start to get into the late 19th century and the early 20th century, can be used as a substitute for evidence about what the right was understood to mean in 1791 or 1868, if you think that's the relevant date.
the traditions he was putting forth were used to exclude Italians and Irish. My family, when they came over here from Sicily, saying Italians need not apply, for him to apply that same logic would be to transpose that to this issue here, and it's just ridiculous, it's racist, and it is unfair. I mean, he's advocating essentially for redlining against minorities being able to defend themselves, and it's terrible. So it's just fascinating, and I definitely encourage you, if you care about our Second Amendment right, go watch these opening arguments. Click our link and watch and hear our commentary as we were going through this. This is an extremely important case, and it's the biggest 2A case since 2010, where it was affirmed McDonald versus Chicago that the Second Amendment is a fundamental right and that also restricts state and local governments from infringing on this right. So go check this case out. We will keep you updated as we learn more. Thanks.